Perfect.
All right. Hi, everybody. Thank you again for joining us today. We are so excited. Obviously, if you haven't seen all over the news, we are very excited to talk about what recently happened at the Supreme Court regarding TABOR. And we're lucky to have our experts here, Carol Hedges, the proponent on the measure, also the executive director of the Colorado Fiscal Institute, and Ed Ramey, who was the attorney for the case and wrote the brief that the Supreme Court was so aptly swayed by. And I am Allie Michelson. I'm the Director of Legislative and Tax Policy here at the Colorado Fiscal Institute. All right, there we go. Working on this here. Here are a few housekeeping items before we get started. We are going to use the chat box for questions. If you look, it should be maybe on the bottom or the top of your screen. There should be a chat box that you can type questions in. I will be monitoring that. And so please type questions as they come up. We're really planning to leave most of this webinar as time for questions. So I might save some of them till the end, but I promise you we will have ample time for questions. Other than that, you will most likely be on mute, hopefully, no offense, until the question period, and also your video will be turned off, as will ours. And then if you have any issues along the way, please raise your hand, or I think there's a little virtual hand raise, or you can chat to me and I will try to address anything throughout the discussion. The only other thing to mention is that we are recording the webinar, and we will be sending the slides / the recorded webinar and some additional information afterward through email. So hopefully when you signed up, we captured your email and we will send you the follow-up information. With that, I'm going to see if I can get slides to move. There we go. I'm going to turn it over. This is a little roadmap of the webinar. First, Ed is going to talk a little bit about the background on why we were at the title board and how the case got to the Supreme Court. He's going to talk about the arguments that he presented to the Supreme Court, and then Carol is going to talk a little bit about the ruling and the next steps in the TABOR fight. So with that, I'm going to turn it over to Ed.
Okay, Allie, thanks. Hello, everybody. Let me just take a few moments about how this whole thing got started. Carol and Allie and the group came to a bunch of us lawyer types and asked us what we could do to change, repeal, amend, eviscerate TABOR in some fashion or another. And our response was, it's very complicated. TABOR itself is very complicated. What you can do about it is very complicated for a lot of reasons. And so we set about exploring them. And one of the issues that kept coming up is there any way, because we understand this just cannot be done, but is there any way that TABOR, that one option for us is that TABOR could be repealed in full, in all parts. And the problem was up behind that was about a quarter century of dicta, I guess I would say, statements by the Colorado Supreme Court that you could not do that. And the reason for that basically is as follows. TABOR was adopted as a ballot measure in 1992, was viewed as containing multiple subjects, meaning different purposes and matters that were not necessarily or properly connected, but that was okay in 1992. But it led the legislature in 1994 to, it led the legislature in 1994 to refer a measure to the voters to adopt in the ballot initiative context, a single subject rule, which says that the ballot title board, and I'll explain briefly who they are in a moment, cannot set a ballot title for an initiative that contains more than a single subject. And if they do, the Supreme Court can reverse that, and that basically is the end of that initiative. It cannot go forward. And why that's important, the way the initiative process works, if a group of people like Carol and Steve Briggs, who are involved in this case in particular, decide they want to present a ballot measure, they first have to go through a process, which many of you may know this, and I'm probably talking about things that everybody knows like the back of their hand, but the first thing you have to do is file your draft measure with the Legislative Council over at the state legislature. They and the Office of Legislative Legal Services do an analysis of the measure, give you a memo, bring you into the Capitol, ask you questions, tell you everything you've done wrong and things that you haven't imagined and why your technical drafting is wrong and substantively what you've written doesn't make any sense, and send you back to the drawing board. It is actually a very helpful, very valuable process. But you go through that, and once you're through that, which takes several weeks, you have to go to a public body called the Ballot Title Setting Board. And the Ballot Title Board is chaired by a representative of from the Secretary of State's office. It has two other members sitting on it, one from the Attorney General's office and one from the Office of Legislative Legal Services. And they do a variety of things, but the first thing they do is make a jurisdictional determination as to whether the measure you're proposing contains a single subject or multiple subjects. And if it contains multiple subjects, you're dead. If they make that determination, you're dead. Now, if they make that determination, you can ask for a rehearing, and then they'll tell you again that you're dead. And then you can appeal to the Supreme Court. And usually the Supreme Court, in most cases, will actually just affirm what the title board does. They give them a lot of discretion, but occasionally they will reverse, which they did here, which is interesting. So that's kind of what we were facing. The problem that we faced is there is and was approximately 25 years of pronouncements from the Colorado Supreme Court that TABOR itself contains multiple subjects. And in the current opinion, it's qualified a bit. They say arguably contains multiple subjects, which leaves kind of a door open there, but who knows? But they have numerous times said that the measure TABOR contained multiple subjects. And that's okay since it was adopted by the voters prior to the adoption of the single subject requirement. But now, since 1994, it is no longer okay. And if a measure contains a single subject, you cannot repeal a measure with multiple subjects. I mean, let me rephrase that again. If a measure contains multiple subjects, it cannot be repealed as a single measure because the repeal would be addressing multiple subjects. And the court has said that over and over and over, primarily in one opinion from 1996, which is called Court versus Poole, and it's 1996 number 4. And if you actually read the Supreme Court opinion, you'll see it referred to a lot because most of the other opinions cited that Supreme Court opinion, that you cannot repeal a measure that contains multiple subjects, period. That's the end of that. So the understanding was that TABOR itself could not be repealed. The one thing about those statements from the court that Carol and Steve and Allie and we were all talking about is every time the court made that statement, it was in the context of dicta. And dicta, for the non-lawyer junkies in the group, are just statements that the high court, the Supreme Court, makes in the context of opinions, but that are not essential to the holding or decision that it reaches in the opinion. It was always dicta. And the fact that something is dicta, usually the lower courts and lower administrative bodies like the title board, if they have any sense at all, will follow the Supreme Court's dicta, but the Supreme Court itself can ignore its own dicta, often does. The US Supreme Court invariably does, and they can do something else. So Carol kept asking the question, why can't we repeal? Are we sure we can't repeal? This is all dicta. This is all nonsense. Why can't we repeal TABOR? And Steve and I were saying, because the court says so. But she says, well, let's find out. Let's try. So we adopted a measure, and actually Steve wrote the measure, which simply said, the measure is to repeal Section 20 of Article 10 of the Colorado Constitution. Period. I mean, that was the entirety of the measure that we set up. We went to the title board. Title board duly cited all the dicta to us from the Supreme Court and refused to do anything other than declare they had no jurisdiction to proceed. We filed a motion for a rehearing. We were there a couple of weeks later. They glared at us again, recited all the same cases to us, and again, denied title. And then we had 1 week to appeal to the Supreme Court, and we did. So we appealed to the court, and interestingly, as is so often the case in briefs that I get involved in, we argue one thing and the court kind of does it, but they kind of do something else. And that's what happened in this case. But the main argument that we were making to the Supreme Court is, first off, look, all these prior pronouncements are dicta. They were never necessary to a decision that the court reached on any of the measures before it involving TABOR or anything else. Having to do with repeals of measures that might contain multiple subjects. Number two is it doesn't make any sense, because what you've basically done is if we repeal a measure that contains multiple subjects, in fact, we are advancing the purposes of the single subject requirement by getting rid of a provision that it exists because the single subject requirement was in some way violated. So we're kind of doing through a repeal what the voters should want us to do. By the way, there are several ways that a multiple subject provision can get adopted. One is the measure is adopted by the voters before 1994, when the single subject requirement was adopted in the state constitution. Secondly, it could go through the title board. Title board could make a mistake and set a title. If nobody challenges it quickly, it can go to the voters. There's no way to challenge, make a single subject challenge effectively after that short period with the title board and Supreme Court takes place. You miss those deadlines, it's adopted. And third, a statute can go through the legislature. And if it contains, they have a single subject requirement as well and have some statehood. But if a multiple subject measure gets adopted there, first off, only so much as is not clearly expressed in the legislative title falls, not the rest of it. And secondly, during the next legislative session, when that multi-subject measure is codified, you can no longer challenge it. So there are lots of ways that multiple subject measures can get adopted, and we were sort of arguing with the court, we ought to be able to get rid of these things. That's kind of what the voters were asking us to do with a single subject requirement anyway. This is not contrary to the intent of the voters. And thirdly, we were making the argument that Carol was most concerned with. What you've done with the way that this dicta has been interpreting the single subject requirement is by preventing a repeal of a multiple subject measure, you essentially make the multiple subject measure impervious to repeal. You can never get rid of it, because you'd have to do it piecemeal at best. And even that would be subject to single subject challenges. You'd remove part of TABOR, say the election provisions. Now what do you do? You've got required elections, but no idea how or where to conduct them. And it becomes extremely expensive. And as the court actually noticed, they picked up on this theme. You've made a multiple subject measure impervious to attack. Not only can't you challenge the fact that it maybe shouldn't have been adopted, you can never repeal it, ever. So that was basically our argument, that this dicta from the court applied, particularly in the context of TABOR, makes no sense. So at that, we waited. Briefing ended at the end of February, I believe.
March,
No, February, I believe. I don't know. Anyway, months. Long time for the court to consider a ballot title appeal from the title board. And the decision came down a couple weeks ago, less than a couple weeks ago, I guess. And here we are. So I'll turn it over to Carol, and you can explain what the court did.
So thank you, Ed. And this is Carol Hedges with the Colorado Fiscal Institute. And I really want to give a big shout out to Ed Ramey, who's creative and tenacious and, quite frankly, patient lawyering is what got us to the place that we are now. And also to the co-proponent of this measure, Steve Briggs, who, in addition to being the co-proponent, along with me, it's required to have two citizen proponents for any initiative. He was really the scrivener and so much more. So really sort of legal brains behind many of the theories that that Ed was then able to translate into a successful appeal to the Colorado Supreme Court. In trying to summarize what the court actually decided, it's a little challenging, and so I'm going to try to stick as much to what is clearly the decision of the court, and if we want to speculate about what else it might mean, be happy to do that through a series of questions. But what the court clearly said is that they reaffirmed the law around what constitutes a single subject. And they said basically there's two parts to the inquiry, and in order to be a single subject, they said everything in the measure must be necessarily connected and not incongruous. Now, for those of you who are lawyers on the call, I don't know about you, but that just like gave me a headache from law school about what that can possibly mean. But that is the language that we're clear, that they repeated multiple times, cited from prior holdings in prior cases. The second thing that, the second component of the test that they believe should be, that they will apply to determine single subject is whether there is, whether the voters can understand what the measure is, or whether there is surreptitious intent, or whether the measure itself is surreptitious. And Ed used some language the other day when we were talking to back at the title board with another issue about that. Is it hidden in the folds? Is there something that people don't understand that's caught up in what you're presenting? And that is, I think the court said that's really what we're trying to avoid. We're trying to make sure voters understand what's going on. So they reinforced that. They said, they established right up front, those are the rules on single subject. It has to be related, necessarily connected, and not incongruous, and that there can't be anything surreptitious about the measure. And so that was the first part of the holding. They went on to say that a measure that proposes to simply repeal Article 10, Section 20 of the Constitution fit those criteria. And that it was very clear to the voters what was going on. It's just asking them to take that section out of the Constitution. Nobody can argue they didn't get it, didn't know what was going on. And quite frankly, they didn't get into a lot of analysis of whether the underlying TABOR had multiple subjects, but they said our proposal had a single subject. We were only doing one thing and one thing only, and that was repealing this particular section of the Constitution. So that's really the holding of the case. I mean, I don't know. I mean, Ed and I have talked about this a lot. Steve and I have talked about this a lot. I don't know. It would be hard to say they said much more than that. And then they said our measure met those standards, and so they remanded us to the title board to set a title for us. The way they chose to deal with this question of whether or the language that they had used in multiple prior opinions, that that's one of our arguments that they accepted, is that it was in fact just dicta. It wasn't actually what the ruling was, but it was just sort of their speculating in a conversation about the rulings, was this language that had been used over and over again that said, if the underlying provision that was being changed or affected was made up of multiple subjects, that repeal measure, and I think they did use the repeal language, was necessarily multiple subjects. And they said, we're rejecting that. That was never the law, right? We didn't really mean that was the law. We were just talking about that in those cases that this was this fact or something. I don't know. I don't know exactly how to characterize it. So the way that I've been thinking about it, I think the way we've been thinking about it is that there is no presumption any longer that something that tries to affect or specifically to repeal a measure that has multiple subjects on its face, that repeal is not necessarily multiple subjects. Now, I'm sure someone out there is saying, huh? Right? And I'm kind of saying, huh, as well. So I think we've all concluded that this is a very narrow ruling that applies to the specific measure that was presented for the court to consider, and that was repeal Article 10, Section 20 of the Constitution. And anything beyond that, as to how to interpret it or what it might mean for future cases, et cetera, is kind of speculative at this point. So I'm not going to spend a whole lot of time speculating about it. If you have questions, maybe you can get Ed to speculate about it. But bottom line, what this means is that as citizens or residents and voters of the state of Colorado, we can consider at the ballot a measure that would repeal Article 10, Section 20 in its entirety. And that is a huge change in the interpretations and the context under which all discussions about how to modernize our tax code, how to make Colorado a place where our tax code actually meets the needs of communities, et cetera, where the context for that debate to occur in. I think it was really, I know that for me, the part that was the most, I guess, rewarding, if that's how I would think about this being, you know, weird emotion to describe it, but is the language that Ed has referenced, and that is that the court very clearly says at the end of its opinion that to conclude otherwise, to find otherwise, that this wasn't a single subject would mean that it would have rendered TABOR, Article 10, Section 20, impervious to change. And they actually go on and develop that argument a little bit, saying that it would be prohibitively expensive because it would require multiple measures that would take a lot of process, and there'd have to be signatures gathered for all of those measures, et cetera. And so this feels an awfully lot like an opinion that was really based in the fact that that couldn't possibly have been what voters intended when they adopted a single subject measure, is to make it so that we couldn't amend our own Constitution. And I think that's sort of, that's kind of where I feel like we ended up. Now, what does that mean? I mean, there was a lot of celebration. Everybody's been very excited, including me and lots of other folks who over the years have come to the conclusion that TABOR's really holding the state back in terms of making the kinds of investments that we need to make make our communities more equitable and better finance our schools and our roads, et cetera. Well, what it means is we have another option, right? We have another tool in our tool belt. It means that if, in fact, that's what we want to put on the ballot, if there's a group, that if that's an option we want to consider, we can. And it really doesn't mean much more than that. It doesn't change any provisions of TABOR. It doesn't put us in a position where it's going to be any easier to do with the voters. It doesn't change anybody's personal opinion about whether TABOR is good for our economy or bad for our economy, or whatever other criteria that a voter would apply if they were looking at such a measure. But it gives us the ability to put that measure on the table, to take an entire section of the Constitution that is just full of complicated provisions, to take it out of the Constitution at the same time. I also want to add at this point that this effort to actually test this question to see what our options are is part of a broader effort that has been in place since 2015 called Vision 2020, that is made up of it's a network of about 40 or plus organizations and plus a whole bunch of individuals who are really interested in seeing what our options are, because we feel like we're kind of holding ourselves back by having TABOR in the Constitution in Colorado. That process is ongoing, And it is a process where we will now begin to look at whether, what options we actually want to take forward. That inquiry and that decision, we want to have informed by as many people as possible, representing as many geographic communities and racial communities and income communities, et cetera, as possible. Because these things are hard to do. Putting things on the ballot and winning is very difficult. It's very expensive. It's very time consuming. And it's really significant for how all of our communities can function. And so we want that the Vision 2020 effort is designed to get as many voices at that table as possible to inform that decision. We will be looking at, and we've already started looking at, options from complete repeal to taking out provisions that require that all income gets taxed at the same rate, which is keeps us from having a progressive income tax, to just taking out the language around the formula, because for those of you who've been following the TABOR debate over time, it contains lots of different pieces. All of those options are on the table. This opinion doesn't tip us in one way or another about what that option is. It just says, if the conclusion that the group comes to is that we really just want to get this thing out of the Constitution altogether, put something else in, or for heaven's sakes, make tax and budget policy like every other state in the country does, and that is between a cooperative process between our elected officials and the residents of the state, then we could do that. That's all this says, is it's a new option. That's where we are. And if you are interested in looking at becoming involved in the Vision 2020 effort, you should be looking at a slide now that gives you Abby Vining's email. Abby is the project coordinator for Vision 2020. Please reach out to her. And also, if you want to have more information about sort of this effort, you can click on or go to the Colorado Fiscal Institute's website to get more information as well. I think I'm going to stop there. I hope we've provided information that clarifies rather than confuses this question. I will say it is a huge source of celebration and hope for many of us who've been working on this for such a long time. And we are really excited to be looking at options for reform that include the ability of, like I said, restoring the Colorado Constitution to a situation where we do tax policy in Colorado like they do in all other states across the country. So I think Allie is now, I don't know if there are any questions in the chat box or not, but we're going to start through the chat.
Yes, we got one great question to start. Now that the court has decided this, how much time do we have to put forth a ballot measure, or do we have to put another title forward next year for the 2020 election?
So that's a great question, smarty pants out there. It is, so we were going back to the title board on the 17th of July with a handy dandy little order in our pockets from the state constitution, or from the state Supreme Court, saying, give these people a title. And that really creates two options for us. One would be to take that measure once the title is established, turn it into petitions, start to circulate petitions, get signatures on that petition. We would have 6 months to get those signatures collected, sent back to the Secretary of State to be certified as valid. If we chose to do that, that could happen, and that would be on the ballot for the November 2020 election. We haven't completely ruled out that possibility yet. But the other option is to say, thank you very much. We were really curious about whether we could do this or not. You've made it very clear, Colorado Supreme Court, that we can do this. And we just get our title and we let it sit. And we do, as the question suggests, come back sometime in the fall of 2019, or maybe early 2020, go back to the title board with this measure or some other, I'm just gonna talk about this measure, come back with this measure, go through the process again, get a title, and then have it certified, get petitions, have it certified for petitioning, circulate, et cetera, et cetera. I will say right now, I think the presumption is that we will do the latter rather than the former, because we really are very, very sincere. At the Vision 2020 Network is very sincere about soliciting a lot of different opinions and views about what the right next step is. And it feels a little disingenuous to say we really want your opinion, but we've already decided what we want to put on the ballot. And once you get those signatures, it's on the ballot. And so that's sort of, that's kind of where we're leaning at this point. But if you'd like to weigh in on that question about whether we should just take what we have and put it before the voters, please join Vision 2020 and make that opinion heard, because you know, that decision has not finally been made.
Awesome. We've got a few more questions. You guys are super smart. These are great questions. The first one is, how are leaders of this effort feeling about the governor's CPR, Colorado Public Radio interview comments going forward?
Well, I think I'll take this one too.
Please.
Well, you know, there's a time at every, you know, there's sort of a moment whenever you're faced with a situation like this where you can choose to pick a fight, or you can choose to believe that we're all working toward the same objectives. And so what I'm going to say now is based in this space that I believe that we're all, including the governor, are interested in and working toward the same objectives, or at least most of the time. And so what the governor said, and the way I read it, and I've looked at it several times now, it was that he supports voters having authority over making tax policy, direct authority over making tax policy in the state of Colorado. And I would suggest that even if TABOR were repealed in its entirety, voters would still have an incredibly important role in tax policy development in the state of Colorado, and not just through the election of their representatives, but through the initiative process. So prior to the adoption of TABOR in 1992, voters had the authority to go to the ballot to approve any tax increase they wanted, or to repeal any state tax increase they didn't like. That hasn't changed. That won't change when or if TABOR is repealed. What this change would do would say that there were more than one way that tax policy could be adopted by the state of Colorado, and one of those would include the legislature doing it. So I'm going to be, in the spirit of cooperation and commitment to common outcomes, I'm going to think that, well, the governor didn't, you know, he may be okay with that. I don't know. I haven't had an opportunity to ask him specifically about that provision. And I will say, if, you know, when you know, that this is a lively conversation, one that is a really important conversation about the future of Colorado. And I don't think it ended with his comments on CPR this week.
The next question is also a smart one. These are all really good. You guys are so engaged. If a repeal or reform measure is put on the ballot in 2020 and adopted by voters, would it impact the temporary income tax rate cut that was projected by Legislative Council and OSPB in the most recent revenue forecast?
Well, I'm gonna speculate here for a minute. It's a great question. I haven't really thought about it. I don't think that it could. One of the provisions, one of the multiple topics hidden in the folds of the Article 10, Section 20, was a requirement that says any tax law change has to cannot apply retroactively. It has to apply to the following tax year. And if I have been able to think quickly enough on my feet, or I'm sitting down, so my rear end, I would think that it would mean that if we went to the ballot in November of 2020 with a measure that changed the tax code, if it was interpreted, which was what I think you could argue TABOR would do, it would take away the requirement of the refunds. I think there's an argument to be made that it couldn't apply until the next tax year, which would begin on January 1 of 2021, which would mean, and the tax reduction is for tax year 20. And so I don't think that even a approval of the voters of a repeal measure in 20 would eliminate the requirement of a refunding of the reduction in the income tax rate that was triggered based upon the last estimate. Now, let me just say that the other thing I will say is that maybe it won't be triggered because this was an estimate, and they actually, if I understand this all right, if I remember how this all right, and Allie and I have spent many hours in front of a whiteboard trying to keep this clear in our brains, but I believe that the actual amount of the refund is based upon an estimate that is given by the auditors, the state auditors, no, the comptroller's office in September. So it's after we've actually closed the books for the fiscal year. And so there is a possibility if for some reason the numbers don't come in exactly like they were anticipated, then that would be changed. Although I will tell you the chances of that are slim to none. I think the other question, and I'm going to anticipate a question that's in there because you guys are so, smart and thinking about all this stuff. The other thing that this brings up in my mind is, well, what happens when voters approve referendum CC, which they will be considering in November of 19, that will say for every fiscal year going forward, any money collected above the inflation plus population formula can be retained by state government to be saved or spent or invested or whatever. I don't know what all that means. I don't think that any of those will affect the ability. I know that the referendum CC is written in such a way that it does not apply to the current year, the year in which we're operating, and that is the year in which revenue is anticipated to be in excess of $400 million, which would trigger the income tax rate reduction. So I hope I haven't confused you further. I swear I couldn't make this up if I wanted to.
We need a little visual whiteboard that everyone can follow along while they watch.
Yeah.
A couple more questions. Another really good one. How does this differ from the Ref C TABOR pause? Would the 2020, sort of a second question, would the 2020 proposition actually fix it?
I'm going to toss it back to Carol, but let me just kind of insert something in there too. One option we have with a measure, if we decided at some point to go with a total repeal, is we can dictate the effective date of the measure. And it can be upon proclamation of the governor 30 days after the election. It can be 5 years downstream. It can be whatever we want to put it. So got to keep that in mind. Carol, you could take the rest of that.
So tell me, I'm sorry. This is what it does.
That is called totally derailing you.
No, he just opens up all these opportunities I hadn't thought about. So can you repeat the question for me, please?
The question is, how does this measure differ from Ref C, the TABOR timeout? And also the second part of that is, I love what she says, will the 2020 proposition fix it?
So if the repeal measure is adopted by voters, it just gets rid of all of the requirements that we have to have rebates, which was one of the challenges, which is one of the things that was the basis of the temporary timeout in Ref C. So I'm going to say it's going to fix the constitutionalized tax code problems, restraints that we have. I want to also, so it fixes it that, but let me just underscore, and this is so important. If TABOR suddenly disappeared tomorrow, our tax code does not generate any additional dollars. It doesn't change the way our tax code, how our tax code collects money, for whom it from whom it collects money. That will require action by a future legislature to take that tax policy, to make that tax change. That is what the whole repeal measure is about. It is about the issue of who has responsibility and authority for making tax policy, it is not about what the tax policy is. The taxes in Colorado will still be single rate, will still be generating the same amount of money, even if TABOR went away. And so then the discussion would be on fix it. It depends on what we mean. Where we would be on January 1 of 2021 if TABOR were repealed. We would be in a situation where there would be a lot of advocates going to the legislature, asking them to make tweaks in the tax code or maybe wholesale changes in the tax code that could accomplish our community objectives. Those objectives would not be accomplished simply by eliminating it, but it would create the opportunity for the voices of community to come together through their elected officials to make tax policy changes.
All right, so if anybody has any additional questions, please feel free to type them. I've also made it possible to unmute yourselves, and I'm not sure what you have to press, I'm sorry, but I can unmute you if you raise your hand. But otherwise, I think we have a really great question to kind of wrap up on. Is there a one-pager available about the court case and possible next steps? It'd be great to be able to share something with our friends, neighbors, and organizations.
So glad that you asked.
We didn't cue that up, I swear.
Well, that didn't come from a CFI address. How about that? There is actually, and that will be distributed to you along with, if you've saw, because we should have your email, it will be distributed back to you after this webinar along with a video or a recorded copy of this in case it was so exciting that you want to listen to it again. So that you can share the recording with somebody else along with this one pager. And we sincerely appreciate the thought that somebody would want to share it. And we strongly encourage you to do this, to share this information as broadly as possible. Because I really do believe that maybe the most significant thing about this decision is that it gives a lot of people who have been struggling with the impact on their kids of a 4-day school week, or have been sitting in traffic because we can't come up with ways to solve our the growing population demands on our transportation system, or that it gives hope to the people who are thinking about trying to get their kids in college here, or people who are trying to get themselves in college and they're worried about how the heck am I going to afford that. There's some hope here. There's a renewed sense that we really do own our communities, and that if we come together and work together and really express what we need, that we will have a way that we can do that through in cooperation with our elected officials. And I think that hope and that clarity that we aren't in a situation where there's nothing we can do is really significant, and I am really hopeful that will inspire all kinds of creative options for what the next steps might be to support to support thriving communities all across our state.
All right, sorry, I'm having a little technical moment.
Okay, I'm sorry, Allie, do you have a question that you want to?
Yeah, we just got one more question, and I'm not sure if you have an answer for this one or not, but somebody asked if there's any recent polling, and I assume that means on I guess maybe on the 2020 measure or on TABOR, or?
So one of the, there isn't, yes, people are always asking the question of whether the citizens like TABOR or not, or whether residents of Colorado like TABOR or not. And I have seen polling that puts it sort of at a 50-50. The most recent I've seen puts it really darn close to 50-50, that some people think it's a good idea, some people think it's a bad idea. The real challenge in polling is, quite frankly, it is a very complicated provision that on a topic that is quite complicated in of itself. And when a pollster starts to ask people's opinion, and there's a great deal of pressure on pollsters to keep these things short because nobody wants to talk for an hour. And they start to shorthand what TABOR does, and they say, well, it gives voters the right to approve tax increases on all tax increases, and it limits the size of government. Well, that's a pretty, characterized in isolation, people tend to see that might have some advantages. I have never seen polling that actually, much of public opinion work that actually digs down into it also means that, as a result, our schools are underfunded and our transportation system is too crowded, et cetera, et cetera. So let's be clear, this isn't a slam dunk. This isn't something that is something that would be an easy campaign to run. But quite frankly, none of these campaigns have been easy. Doug Bruce and the proponents of the TABOR amendment ran it 3 times before it was adopted as part of our Constitution. And I do believe the one thing I am absolutely sure of is frustration with the constraints that this constitutional provision have put on our community's ability to solve their own problems is at an all-time high. But in terms of actual polling numbers, I haven't seen anything in quite a while.
All right. Well, it looks like the questions have kind of petered off. So I might take this chance just to remind you all that we will be sending some follow-up information, including the recording of the webinar and some things that are easy to share, and some information on how to continue to be involved in the Vision 2020 work and stay updated on the next steps in the TABOR repeal. Otherwise, thank you so much for joining us today, for all of your great questions. And I think hopefully you know how to get a hold of us if any other questions come up. So
thanks, Ed.
Yes, and thank you so much to Ed for all he has done and for joining us today. And yeah, thanks everyone.
Bye.